The Supreme Court is now being asked to weigh in on a major Second Amendment case, whether a state can enforce its own Second Amendment Preservation Act to declare itself a sanctuary for gun rights. But there's been yet another delay. The Trump administration has decided to take more time before making a final decision on how it wants to move forward with this case. If you'd like to support the channel for free, hit the subscribe button. It really helps the channel grow. And if you can, leave a positive comment below. Every comment helps signal to the algorithm that this content matters and should reach more people who care about their rights. Now here's what's happening. This case centers around Missouri's Second Amendment Preservation Act, often referred to as SAPA. You might remember we've covered this before. Not long ago, the Supreme Court denied a request from Missouri that would have protected the SAPA law at an earlier stage. Following that denial, the case was kicked back down to the Eighth Circuit Court of Appeals. Recently, that court sided with the Biden administration and ruled that Missouri's SAPA law is entirely invalid. The Eighth Circuit argued that the law tried to override federal gun laws, which they said violates the Supremacy Clause of the Constitution. In response, Missouri has now formally petitioned the Supreme Court, asking it to step in and overrule the lower court's decision. They're arguing that the state has a right to protect its citizens' Second Amendment rights without interference from the federal government. So now the Supreme Court must decide, will it take up the case and allow states to declare themselves Second Amendment sanctuary states? At the same time, the Trump administration, which many expected to lean heavily in favor of gun rights, is still deciding how it wants to handle this case. For now, it's chosen to delay any formal action. This case could have serious implications for the future of gun rights and the ability of individual states to shield their citizens from federal regulations they believe go too far. We'll be watching closely to see what the court decides and how the Trump administration ultimately responds. For those who aren't familiar with the background, Missouri passed the Second Amendment Preservation Act, or SAPA, back in 2021. The purpose of the law was to clearly define Missouri's position on the Second Amendment and to limit how much the state would support federal efforts to enforce any gun laws it believes violate the Constitution. Under SAPA, Missouri's law enforcement officers and government officials are prohibited from helping federal agents enforce such laws. What makes this law even more unique is that it allows any individual in Missouri to file a lawsuit against a government official who assists with enforcing those federal laws that the state deems unconstitutional. This structure mirrors how Texas approached its controversial abortion law, known as SB 8. Both laws are designed in a way that makes it difficult for federal courts to block them broadly. Because the laws rely on private civil enforcement, there's no clear state actor to sue. That means if someone wants to challenge these laws in court, they'd have to individually go after every single private person who tries to enforce them, making it incredibly difficult to stop the law in practice. In Missouri's case, the district court sided with the Biden administration, striking down SAPA entirely. Missouri then appealed that decision to the Eighth Circuit and asked for a stay to pause the lower court's ruling while the appeal was pending. That stay request was denied. That led Missouri to file an emergency application to the U.S. Supreme Court, asking for a stay to keep SAPA in effect while the legal battle continued. The Supreme Court denied that request in an 8-1 vote, with only Justice Clarence Thomas voting in Missouri's favor. After that denial, the case went back to the Eighth Circuit for further arguments. The court moved quickly and has now issued its final decision, once again siding with the Biden administration and striking down the SAPA law completely. Now, Missouri has taken its case back to the Supreme Court, this time by filing a formal petition for certiorari. They're asking the court to hear the case and overturn the lower court's decision. In this petition, Missouri is asking the Supreme Court to consider 3 key constitutional questions. 1. Can federal courts question a state's motivation when it acts under its 10th Amendment authority? 2. Does the Constitution stop states from using 10th Amendment powers just because their motivation is concern over the constitutionality of a federal law? 3. Is a state official a valid defendant under Ex parte Young simply because they're subject to a law, or do they also need enforcement power for the law to be challenged through them? These questions go beyond Missouri. The answers could shape how much freedom states have in resisting federal laws they believe go too far, and whether similar sanctuary laws in other areas could be upheld or struck down. In their petition, Missouri argues that what happened in this case is unprecedented. They say that before now, no federal court had ever struck down a state law simply because of the reason the state gave for using its 10th Amendment authority. But in this situation, that's exactly what the Eighth Circuit did. According to Missouri, the court didn't strike down the law because of what it actually does. It struck it down because of what the legislature said. The court disagreed with the law's stated purpose, that certain federal gun laws are unconstitutional. Missouri points out that the court even admitted a similar law with the same effect would likely be allowed, as long as it didn't include the same kind of Second Amendment-focused legislative findings. So essentially, the court said the structure of SAPA is valid, but the intent behind it, protecting the Second Amendment, was not. Missouri strongly disagrees with that reasoning and argues that it's both legally incorrect and deeply concerning. They also note that this decision by the Eighth Circuit creates multiple circuit splits, which means different federal courts across the country are now handling similar legal questions in conflicting ways. Another reason why the Supreme Court may need to step in and resolve the issue. Another key point Missouri raises is how the Eighth Circuit treated enforcement. The court found that Missouri officials could be sued, even though they weren't actively enforcing the law. In fact, the court treated their compliance, or even non-action, as a form of enforcement, making them vulnerable to lawsuits and potential injunctions. Missouri says this interpretation goes against established legal precedent. Originally, the Biden administration opposed this law and led the challenge against it. But now, with the Trump administration back in control, they've inherited this case, and with it, the responsibility of deciding how to proceed. The federal government was supposed to respond to Missouri's petition by February 26th, but they've now asked for and received multiple extensions. Most recently, just before their next deadline, the Trump administration requested more time once again. The Supreme Court granted that request and has now given them until June 10th to file their response. That means the future of Missouri's SAPA law, and the broader question of how much power states have to resist federal gun control, now hinges on how the Trump administration decides to handle this case. One important detail in this case is that the petition wasn't filed by the federal government, it was filed by the state of Missouri. That means, unlike past petitions where the administration could simply choose to walk away, that option isn't on the table here. The federal government will eventually have to respond and give the court an official answer. Now, it's likely that the Second Amendment Task Force is watching this case closely. They're probably working behind the scenes to figure out how to approach this from a pro-Second Amendment standpoint. That's especially relevant because the current U.S. Solicitor General used to be Missouri's attorney in this very case. Back then, he was defending the SAPA law against the Biden administration. Now he's overseeing the very office that must respond to this petition. While he's recused himself from directly handling it, his influence and legal philosophy will still shape how the response is crafted. The Trump administration has already been granted several extensions by the Supreme Court, but that can't go on forever. Eventually, a response will have to be filed, and the administration will have to take a clear position on this issue. For now, though, it seems the court is willing to let the administration push this down the road. There's a chance the court simply doesn't want to deal with another major, politically sensitive case right now. And it's not just the SAPA case hanging in the balance. Everyone is also watching the court for updates on the sniper rifle ban case and the Ocean State Tactical Magazine ban case. While the SAPA law likely won't be addressed this term, there's still time for significant movement on the rifle and magazine ban cases. Many are hoping those petitions are granted before the term ends. A denial would be a major setback. There does seem to be a sense of delay coming from the court, maybe a reluctance to take on controversial Second Amendment cases at this moment. Whether that's by design or circumstance, we'll have to wait and see how it all unfolds. As for the Trump administration, this could simply be a strategic decision to keep the SAPA issue on pause for now. That's the latest on the SAPA case at the Supreme Court. As more updates come in, I'll continue to keep you informed. Thanks for watching. Be sure to like, leave a comment, and subscribe if you haven't already.